Finance Committee to order. We have a quorum, Mr. Weezer, Mr. Koretz, Mr. Rosenthal, myself, Bernard Parks, as chair. Colleagues, we have 8 items. We have 4 of them on consent, and so, I'm sorry, not 4 on consent, 4 in closed session. And so if we can do those 4 and then come back and deal with 5 through 8, we can address the agenda. So,
and this is just a point of privilege. I have to do a press conference at 1:30 on a document that I just got at 1 o'clock. And I want to make sure I'm here for the red light.
okay.
So,
All right. So we're going to go into closed session on items 1 through 4. On the regular meeting of Budget and Finance, we have a full committee, Mr. Weezer, Mr. Englander, Mr. Rosenthal, Mr. Koretz, and myself, Bernard Parks, as chair. We're going to go to item 5.
5 is a communication from the city attorney and ordinance relative to adding a new subsection to section 5.1777 of the Los Angeles Administrative Code to provide authority for settlement by the city attorney of certain workers' compensation cases.
Councilmember Peter Echeverria and Carl Moody from the city attorney's office. During recent months, but actually for the better part of the last year, we've encountered a situation with our workers' compensation cases where the judges before whom we appear are more and more frustrated by the inability of our lawyers to stipulate or settle cases in which there are statutorily mandated payments that are involved, and that involve essentially just the statutorily mandated payments. The ordinance that's before you would clarify and expand our authority, the authority of our attorneys, to settle cases still within $50,000 for all amounts that are not that would be discretionary payments, if you will, that are not statutorily mandated. And I have Carl here to explain to you, since he's our workers' compensation expert, to explain to you what those payments are and what the circumstances are that led to this recommendation. I might add that approval of this ordinance would not have an adverse financial impact on the city, since these are statutorily mandated payments that the city would have to make under any circumstance. The incidental benefit to the city would be that there would be less time consumed by our attorneys having to process the reports that are prepared and that I sent through the system, and would take less of your time as well in considering those.
Yeah.
I'll ask Carl to give you some background.
Carl, when you start off, could you just give us what the statute is and the legislation that we're responding to?
Well, the primary concern we have is that until November of 2008, the California Workers' Compensation Rules of Court Administrator, Rule 10-563, required that upon notice of a hearing, all parties had to appear at that hearing and have settlement authority, either at the board or to have access to an individual with settlement authority that they could reach and arrive at an immediate settlement authority at the board. That legislation, or that statute at that time, had a clause at the very end of it that said, regarding governmental entities, their representatives must be present at such hearings with settlement authority to the fullest extent of the law. That clause, those 7 magic words, we've used for the last few years, or until 2008, to remind the judges that the city ordinances, the city charter and administrative code is law that we're bound by. So to the fullest extent of the law, we couldn't settle a case over $50,000 without going through this process, even though the benefits were statutory. What happened in 2008 was that statute was repealed and was reenacted with a new rule, 10-420, and that rule left out those 7 magic words. And in fact, it says no exceptions. Since January 2009 and forward, we've encountered continued resistance from the judges who expect us to be there with settlement authority. For example, the Los Angeles County attorneys can settle up to 99% and have been able to do that for many years. Most insurance companies' authorities are limited to that extent, but the city was unable to do so. And during the last year, this has gotten to the point where the last 3 or 4 months, for example, we've had a number of hearings where the judges advised us that they're going to issue sanctions in the rulings when the case had to go to trial because we couldn't settle it that day. Our position is, and has to be, I think, that the benefits that we're looking at are only those benefits that we are statutorily mandated to pay. And as the members of the board, I'm sure, have heard me say in the past, we're here to ask permission to settle these cases, but in fact, we're already paying most of them, because the law says that at that point in time when there's no further dispute about the entitlement of an injured worker to these benefits, we must start paying them within 14 days, or we end up having to add penalties and interest to those funds. So we don't anticipate that we're asking the board to give us authority for discretionary items such as penalties or even a compromise and release where we're giving the applicant additional money to get rid of future medical, because those are not mandated. That's not something that we have to pay. This ordinance would only cover those benefits: temporary disability, permanent disability, medical treatment, life pension if the disability extends to that level, and death benefits when there's no dispute about these benefits. Other than that, the policy would remain the same.
Okay. And then let me just ask on the issue, I'm reading the ordinance. One thing that was unclear to me is that if it's mandatory and statutorily required to start the payments within 14 days, if those payments are started, what is the harm of our current process?
Well, we pay the benefits, but we still have to execute the final documents for the board. And that's when the judges are upset. They know we're paying the benefits. We always point that out to them. But the applicant's entitled to have those papers signed, and if we're not able to do it, the case has to stay on calendar until we can.
So they wanted final authority to settle it at that time?
That's correct.
Okay. If we're unable to do that, is that a potential that it goes to trial, or is it just carryover?
The judge has the option of requiring the parties to go to trial immediately, and I have to tell you that when that happens, we usually pay more money. Yeah. I did an audit myself shortly after taking this position, looking at a number of cases where we were compelled to go to trial because we didn't have that settlement authority, and 28 of the 30 cases I looked at had considerably more money in some cases, that the judge's award was more than what we had worked out in an informal settlement with the other parties.
Just quickly on this, on the apparently most of it's non-discretionary, but anything that's over and above the amount, under the $50,000 threshold, but if there are any charges or claims over and above what's not on the entitlement list, would that then come to council or committee?
Yes.
Yes.
For example, we envision that there are cases for example, an employee may file a claim of 132A penalties, alleging that the city discriminated against him or her in some way because they were injured or because they filed a claim. Those are claims for money damages, in my opinion, and they are discretionary. We can fight those, and in fact, we usually do. At some point in time, if we come to the conclusion that the city was wrong in some aspect, we may negotiate a settlement, but any such settlement that exceeded those limits would clearly have to come back before this board.
And then, and you said exceeded those limits, not being the 50,000, but what's actually on the entitlement amounts. That's what I was referring to.
Yeah, the only amounts that are going to be outside of the 50,000 are those benefits that are specifically non-discretionary, that are in fact part of the workers' comp entitlement program, where the benefits are statutorily defined, and the procedures by which we determine the value of those benefits are also statutorily defined.
So, you made the comment, and it's in the report, it says here in the draft ordinance that it's 99% of the time, those are statutorily defined. So if that 1%, or the ones that are typically,
No, I think that refers to the maximum that we can stipulate to is a 99% disability. And the reason for that is pretty obvious for us in the system. We don't like to ever stipulate to 100%. We'll try most of those cases simply because the difference between 99%, which is, $150,000, for example. I don't have all the numbers in front of me, but let's say 99% is $150,000 in PD indemnity. The 100% no longer has that attached to it. It becomes a life pension at the maximum temporary total disability rate retroactive to the date of the injury. If I've got a 30-year-old employee who's going to live to 84 or 85 years old, and we're going to pay him $1,000 a week for the rest of his life, that's huge. And those cases would still have to come back to the board, or we would try them and attempt to get a judge to be persuaded that this person's not 100%. But we won't be stipulating to very many 100%
and
cases.
there's a final question. Since they won't be coming to this committee under the 50,000, if they meet all these conditions based on this ordinance, well, then, would we receive some type of regular schedule of what settlements have occurred, since they're going to happen on their own
We're going to ask for a report back.
We can provide reports back on that.
regularly? All right. I got that.
Was it?
For the record, the city attorney is to approve settlements of $100,000 or less. Does this prohibit us from being able to review the case, hear the pros and cons, and voice our vote?
Absolutely not. You can always ask for reports on any particular case, and we would report to you.
Who in the city attorney's office actually reviews the cases and makes the final decision? Is it a high-ranking staff or the city attorney himself?
Mr. Moody would, in virtually all instances where there are any doubts or questions, or I've asked him to come up with protocols for the approval of these settlements above a certain amount, then it would be the head of the civil branch, which at this time happens to be me.
The city attorney states that due to a recent change in state law, this now is how we should operate in the city of Los Angeles. What is the state law specifically?
That's the ordinance where the parties are required by law to appear at these hearings with settlement authority. And that settlement authority, of course, we don't have if it's over 50,000. And we have, because of the increase in the cost of these benefits over the last 10 or 12 years, it's getting to the point where we're getting more and more of these cases that do have to be delayed to go through this process. And that's what's causing the conflict with the judges and the board.
The state law itself, have we analyzed it? I know the politicians made the law. Do we think it's a good law? And if we have problems with the law, is it possible for us to at least make a statement to that effect in our legislative packet and go back up to Sacramento or possible and modify the law? I'd just like your opinion of this law.
I'll let Carl expand upon this, but good is a relative term. I mean, the system is intended to provide the maximum protection within the law for workers who are injured on the job. So it is expressly intended to be applied in the most liberal fashion to provide benefits. So is that a good thing? I think societally, I think the answer would be yes. Is it a good thing fiscally for the city in every instance? I would say no, not necessarily.
Take that one step further on that. I appreciate that. So, obviously, say, for instance, I have diabetes and heart disease. And I'm 66 years old. And I ain't suing nobody for nothing the rest of it. I know it's part of the natural aging process. Stress we all have. We live in a stressful society, and it's a stressful world. But we also are aging. And so some of these issues that I have had some issues with are the normal aging process, and I call it double dipping. Dipping back in, getting money, and still staying on the job, getting the retirement check, an extra bump of a couple of $100K or whatever the story is. Is that part of the frustration we have as a city, and are these particular issues addressable?
Well, absolutely. You're preaching to the choir when you talk about some of these benefits that we look at the same way you are, I think. But as Mr. Echevarria stated, the law right now is that the labor code basically says that the judges have one obligation, and that is to protect the interests of the injured worker. and they are to liberally interpret all legislation, all the laws and rules to the benefit of the injured worker. Now, legislatively, yes, if the city council and all the cities and counties and these various, the big major players were to get all their lobbyists up there to look at some ways to change some of these cumulative trauma type injuries, that is certainly something that the political body should consider, but it isn't something that I can deal with at my level. My level is, I'm in court, the judge wants me to settle, we don't dispute the benefits, they're statutory, it's an entitlement program. I want to be able to write the check when we can sometimes get a better deal than we can get if we have to go to trial.
No, I certainly appreciate that, and that's obviously what we've been doing here. But what I would like us to do is look at it from the standpoint that I just discussed and that you just reacted to. And if we could tweak the law, or modify the law, or put an addendum to a law, or change the law, I'd like to know what options we might have. I know Mr. Koretz might ask a question or two. He's a state assembly member formerly. He knows that process up there as well. But for me, it's a fairness issue and a double dipping issue when it is a natural condition of us getting old. Those particular issues I find offensive. In the private sector, people my age bracket knew that there was this opportunity that people could double dip. In that context, it would be outrageously received. And I know, because I sit in budget, I sit in closed session, I vote yes and no depending upon the situation, but there is what I consider to be some outrageous behavior within the context of these laws. And I'd like your analysis of it to see if we as politicians have the courage to take some of this to the next level. Can you get a report back on that?
I would be happy to draft something that would indicate what we feel would be possible as legislation that might alter some of these presumptions or cumulative trauma type injuries.
I appreciate it. Thank you so
Certainly.
much.
Well, and to follow up on that, when I was in the legislature, I probably voted for them. I might have even authored one or two. But I think what we probably weren't focused on are some of the abuses and stretches of those. I mean, there's certainly many cases where it's very legitimate. But I'm seeing more in this position. You know, we're hearing cases where we know it's not legitimate. We know that people have stretched the law to their own purposes. And I don't know if there's some way to craft something that would be a little tighter that attempts to limit those to the real cases and find some way to give a little more oversight to the other ones.
Well, you won't find any disagreement from me. I think Councilman Rosendahl knows that last Wednesday he voted no on a case that I did tell him in candor that I wasn't comfortable with, but it was one of those cases where the system had spoken. You're innocent until proven guilty. We can feel all day that a case may be valid or not valid, but if you're not able to prove fraud, if you're not able to prove certain things, you're stuck with the record you have, and that's it. But I agree with you. It's an issue that has to be addressed, and we try to address them. We litigate many cases. We don't come here to settle every case and ask you to make the decision. We try cases every day of the week, practically, where we disagree with some point and have to let a judge decide.
And I know it's always been tipped to liberal application and protection of the worker, but I briefly was on the other side when I worked for the State Compensation Insurance Fund as a claims adjuster, and I actually my favorite was a case where we suspected we were being defrauded, and we caught someone who was permanently totally disabled playing a very vigorous game of tennis, and we presented it in the video in court, and we actually lost. And the guy said, well, I was just having a good day. Normally, I'm totally permanently disabled.
I was on my pills that day.
But I somehow, even though I'm normally disabled, I was playing a pretty good game. But unfortunately, that's the way the system is. And I don't know if we could attempt to sponsor a bill from LA to tweak that a little bit. But I'd certainly be open to doing that if we could attempt to limit these things to only legitimate cases in some way.
Well, we would be more than happy to do what we can to assist you in that.
Okay. Let me just ask a couple other questions. Is that, just so we're clear on what the new procedure will be, when we have a circumstance that falls under the new ordinance, then our expectation is the Claims Board nor the Budget and Finance will see those cases that are mandated by statute. And so therefore, they will be dealt with strictly within the city attorney's office.
Correct.
Okay. And then the new ordinance does not affect other settlements under the current criteria of 50, and so nothing else
only
other than
workers'
this
comp.
small segment.
Only workers' comp and only those that involve the statutorily mandated amounts.
Okay. And then the other issue is that because of the fluidness of the operation, would there be an ability on these types of cases where you could obtain a pre-approval from the council, or is that pretty well eliminated by the fact that the judge wants you present in court?
It would be when we're before the court, essentially, we'd be stipulating to the judgment.
So pre-approval from the council, again, is still legislated, so it's not any
Correct.
real discretion.
Correct.
Okay. And then on the report back, what we'd like to do is get a report back to this committee and council. And I was trying to figure out with the number of reports that you send us, whether this could be merged into any, but I think it's kind of like a standalone.
We can do.
It doesn't deal with.
Right. I mean, initially, what I can ask Carl is come up with a listing of these cases that would be a report, essentially listing these cases periodically, say on a quarterly basis, that gives you a list of the cases, a very brief summary of them, and the settlements.
Okay. So we get a quarterly report as a standalone report on these types of litigation to this committee and to council. Let's see. Also, we'd asked an instruction, as what Mr. Rosenthal requested, is that the city attorney evaluates if there is future litigation to address some of the concerns regarding the continuous trauma and other
Legislation.
issues.
I'm sorry. Future legislation.
Legislation.
Yeah.
So that we asked that as an instruction that the city attorney come back and give us some indication of whether that's appropriate to be put into a future legislative calendar for the council, and dealing with the issues that the shortfalls that we've been identified.
So I understand you're asking us to maybe draft some proposed legislation or something that would help alleviate this if it
Alleviate
was
some, yes.
enacted?
That'd be great.
Okay, so that would be a instruction. And then my final request is if we could ask the CLA in their office to look at the ordinance and the rationale as it relates to the council's authority. So those are all the issues related to that particular number 5, and we'll move it with those instructions.
Thank you.
Thank you.
Thank you very much.
Thank you.
It doesn't.
Okay, that takes us to item number 6, but was item 6 an item you want to take on consent?
No, the thing is, I'd like to just get some clarity on 6 so that we're aware. It appears that they're making some dramatic changes from what appears to be the original intent of the
Okay.
ordinance, and just some explanation of.
Sure. Item 6 is communication with the city attorney and ordinance relative to expanding the pool of students eligible for scholarship money from Hernani Bernardi Scholarship Trust Fund.
Let me just ask, on the original intent, do you have any insight, because it appears from the recommendation that they're making some dramatic changes, and whether these are inconsistent with the original intent of the scholarship fund?
The current code section that provides for the scholarship applies to students enrolled at the Mission College. What the draft ordinance does is expand that pool of students to all eligible students in public institutions in the city of Los Angeles. And by the way, you should have a new draft that was filed today that actually clarifies that. The previous draft talks about all students at all higher learning institutions in the city of Los Angeles. The amended draft, which again was filed today, I don't know if you actually have a copy, limits that to students enrolled in all public institutions in the city of Los Angeles.
Yeah, the last one, the one I have in our book is July 11th.
July 25th.
Okay, so now you have a new one.
Yeah, well, I'm sorry, I only have one copy if you want.
What is the difference of the applying it to, because at first it was mission, and then it appeared that the July 11th dealt with all higher education institution in the city of LA?
Correct, and now that pool of institutions is narrowed to all public institutions, higher learning institutions that are public in the city of Los Angeles, as opposed to all of them. For example, USC would not qualify because it's not
Public instead of all.
correct.
Okay.
And that was in response to further discussions with CD7.
Okay. And then the change in the, do we, again, what concerned me, and again, it's something that's a local issue, but what concerns me is that we have no insight as to the original intent and the framers of the foundation initially, or the fund, and we're making some dramatic changes from mission to a larger scope. We're changing the dynamics of the board, and those things, and I just have a little discomfort not knowing what, in the sense of whether the original intent of, and I'm assuming because it was named after Mr. Bernardi, that he may have had some role in it and made some very specific directions, and here we're talking about making them, without that background, I have some discomfort to know whether we should be going in this direction.
Certainly, the awards panel is different. There was no limit to the number of members on the panel in the original draft, in the original code. Now that is limited to 7.
What was the number before?
Whatever it was agreed upon between the council offices. There was no specific number. Now it's a specific number. There are 7 of them, 5 appointed by CD7 and 2, I believe, by CD2.
Okay, and then do we have any idea how much the funds that are in this particular scholarship fund?
I do not. So.
Just the way I was going to ask how much we had in the fund. How much was originally, is this an ongoing, is there a revenue stream on this fund? Or is it just, was it a one-time allocation to it?
To be honest with you, I could not determine where what is the source of the funds. I know that the city clerk is administering this, but I do not know where the fund is, where the money is coming from.
So we don't know if there's ongoing contributions to this fund, or if it was just a one-time payment?
Sorry, I do not. I'll try to find out. I'll contact the city clerk.
Okay. Bill?
I will check with the city clerk and try to find out both how much money there is currently and the original source of the funds.
Yeah, I have some of the same concerns that Mr. Parks does. Not only do I not know what the origins were and whether this meets with the original intent, which it would seem that it doesn't, I also have no idea why we're looking at making this change and broadening it to what generated this activity, and what are they getting at by trying to make these changes? What's the intention?
Well, obviously the main purpose is to expand the pool of eligible students, going from Mission College to basically all students potentially in all public institutions in LA.
I don't know why we're doing that, though. I mean, I don't know whether this is a tiny amount of money or a significant amount of money. It seems like it was targeted for Mission College, and spreading it out among the entire city seems like it would certainly dilute it. I think we'd need a lot more information before I'd feel comfortable voting for it.
Okay. Let me just ask if we just hold this in committee and several things we need before we reschedule it is that, is the original ordinance or intent of the Minority Scholarship Trust Fund. We'd also need the rationale for the expansion from Mission College to all public institutions. Also, we'd need to know the endowment, whether it was a one-time endowment or whether it is an ongoing cash flow, and how those funds have been used since the creation of this fund. And also the rationale for the change in the makeup of the board as it's currently constituted versus how it is recommended. Those are things I think we'd need before we could move forward, and we'd ask that we get that information. If we need a representative from Council District 7 at the next meeting, but we'd like to have something in writing that would advise us as to why these recommendations, and so we'll hold it in committee till we get those. Okay, thank you.
Thank you.
Next item.
Item 7 is an Office of Finance report relative to the accounts receivable quarterly report for the third quarter of fiscal year 2010-11.
Todd Bowie, Office of Finance. It's like an overview of the report.
Yeah.
The-
You know what would be helpful, I think, because you're in transition, and I know FMS is somewhere out there, and we're just getting into it. If you would just briefly kind of walk us through this report and show us what some of the issues are and what the changes we could expect, but just a quick analysis, because I guess this would be called a kind of a interim report until you solidify what the future report will look like.
That's correct. So this is a bit different from reports in the past. I think this one is a bit more detailed. We've provided breakdowns on principal, interest, penalty. Guideline, the time buckets are more closely aligned to citywide guidelines. And so, as you were mentioning, we are transitioning to not only a new system with the new financial management system that just went live in July, and there are a number of departments using that system for their accounts receivables. But there have also been a number of new systems that have come online over the past couple of years, notably with the Police Commission and the Fire Department have both implemented new billing collection systems. And as we're moving forward, December, we are implementing a data warehouse that's going to aggregate all the information from 10 different accounts receivable systems throughout the city. And then from there, we'll be able to produce a lot more robust reporting than what we have now, which is very summary level reporting that we're getting from departments. And so we'll have, I think, a lot better reporting and insight into that. And actually, even for the fourth quarter that's out right now with departments, and we'll get that information back shortly from them, we're introducing some new things too. We're going to have departments start reporting on amounts they deem uncollectible. I think that should help in terms of clarifying amounts that are realistically collectible, hopefully. And we're also going to introduce having departments provide information on lien holds, and also give departments the option to customize their templates to fit their business processes better for those that have deviations from guidelines for ordinance reasons and whatnot, such as ambulance services and parking citations. So there's a great deal of transition, and we're continually trying to improve the reporting and provide more information and insight into the status of accounts receivable in the city, because we've noted there's been a lot of attention to it, and there's been a lot of big numbers that have been bantered about, most notably here. Now, when you're talking about the outstanding receivables, so this is as of March 31st, 2011, point-in-time information. The amount reported is $590 million, of which $30 million was current. And this is very similar to the amounts reported in the CAFR. And I know this amount has been kind of kicked around, but in reality, it's not. It's significantly aged amount of receivables, most of which is likely uncollectible. And so what's been occurring here is that we've basically year to year had amounts that have been accruing on the books, and without write-off processes in place for certain receivables, this amount has grown and grown and grown into a balloon figure. And it's certainly not to reflect that there's $600 million that is collectible. This is, like I said, reflects an extended time period. And actually of that amount, about 90% in this report of that $590 million is related to two receivable types, parking citations and ambulance billings. And again, that has a lot to do with not pursuing a write-off process. Now, both of those departments, as I understand it, are working on that now and should be initiating write-off processes in the, hopefully as soon as the first quarter of this fiscal year. And so if they are able to do that, we should really see a dent put in that number and have a much better idea as to what's truly outstanding.
Let me just ask you, there's two things I think this committee has asked a number of times. One, dealing with Executive Order 5 and getting some cooperation to where the mayor's office places some emphasis on that order so that we can get departments to make it very, very clear how important it is that they comply. And it appears is that we're still chugging along with non-compliance. The other thing we asked a while back, and it's more towards the fire department, that we shouldn't actually put that debt as receivables when we know it's uncollectible, because all it does is create a number that's unreasonable, and it's one of those numbers that we'll read about until the next report comes out. And we've gotten some assurances well before the financial management report was going to be completed, or the system was going to be completed, they were going to stop putting uncollectible debt that's by law. Because you can't collect by law. Not the uncollectible that we had difficulty finding, but the uncollectible by law.
Yeah.
They weren't even going to put that in the receivable figure.
Yeah.
And so have we had any headway in getting those two things accomplished in the sense of Executive Order 5 and determining billing?
Sure. In terms of Executive Order 5, the mayor just recently resent that executive order, reiterating that departments were to comply, and even went so far as to extend the directive to include that directives of finance to departments regarding billing and collection processes should be treated as mayoral directions. And I do believe in the kind of the short window of time that I've been involved with this, and that since this has occurred, and also with the bringing on of CORE and also the council and the controller attention on this area, that I do believe that departments are trying to move forward. We've seen a lot of activity with departments doing write-off processes. I think that we'll see even more reflected in the fourth quarter. And but like I said, most of the departments won't put much of a dent into it until the fire department moves forward in that process and kind of closes the loop on their receivables. But as they've indicated, they are working on that and are planning to prepare to send things for write-off.
Let me ask you, what's the difficulty? Because it seems fairly simplistic. We understand that they'd have to wait for the fire department longer than the 45 days. But it seems fairly simplistic to know what legally cannot be charged, that they wouldn't even put that in the category. I mean, and again, we've only been asking for that for 3 years. And then the other one that seems fairly simplistic is Executive Order 5, that's probably been republished at least 3 times. The only thing missing is, please, will you follow the executive order? And so I just don't understand why we're here today in these issues. Every time we get one of these reports, we ask the same thing, saying, can you get these things corrected? And yet they keep coming back the same way.
I think with fire department, in their new system, which they implemented, I believe in November of the past fiscal year, their new system does make accounting adjustments for those amounts that are not legally collectible, such as with a Medicare, for instance. So if you were to, the situation as it is now is if you were to bill for $1,400, but you could only collect $400 legally. And so under the new system, they will be able to make those types of adjustments. with a lot of the older data and they're from their old system, those adjustments, as I understand it, never really occurred. And so it is a matter of someone basically going back through those old records and making those adjustments, as well as with the write-off process too. So the write-offs for the amounts from the old system, again, is I think a little bit of a manual process for them that they have to undertake. And so kind of what has been communicated to us has been a little bit of resource or staffing related issues to getting that done.
Is there someone in the mayor's office that's responsible for Executive Order 5, or does that fall totally on the shoulders of Office of Finance?
It is under the purview of finance, but we do liaise with folks in the mayor's office, and particularly through their budget team.
Okay. And then my final question is that can you give us the current status of the primary and secondary collectors, RFPs, when they would be coming out and going out to the public?
There was, we just signed the secondary collection RFPs back in, I believe, December. There will be another round of RFPs to replace the current ones, the current contracts. That won't be until, I believe, September of 2012.
So, but all of them will come due at the same time?
Yeah, we're going to sync them all up.
Okay. We just asked you, again, from this committee, that we not allow those to lapse, and that we are clearly moving forward to make sure that there are current, that we not have a time period in which our collection process is not available. And if I understood when we went out for the secondary, is that when we do the new RFPs, that all the primary and secondaries will be able to bid on the RFP?
Yes, I believe that is the concept.
Okay, now, will there be a secondary in the future, or will they just be primary, but they get less work than the current primary?
I believe that there will, the plan at this point would be to have both primary and secondary. And so, though it's not, obviously the RFP hasn't been developed yet, but I think the concept is that you could come in and bid on both. Now, you can't work the same debt. So you can't be both the primary and the secondary for the same debt, but we would set it up so that you could be interchangeable.
Thank you. Okay, if we will move this item, and we just ask one instruction, is that we ask Office of Finance to again work with the mayor's office to identify a point of contact regarding Executive Order 5, so that we will have some more clarity as to the responsibility, and that we again ask the paramedic billing to cease adding legally non-collectible debt to be added to their receivables. And so we can move with those two instructions.
All right, that takes us to item number 8, which is a motion, Cardenas Parks and CLA report relative to the photo red light program.
We have 3 public comment cards. Punch it down, June. Bring up Mr. J. Is it Bieber, Ray Carosa, and Rose, or is it Boise, and Ducey? Those 3 names.
Hello, my name is Jay Bieber. I'm with a group called Safer Streets LA, also on the board of the Sherman Oaks Neighborhood Council and the Pedestrian Safety Advisory Committee for the City of LA. There's a couple of things that have been talked about in terms of this issue numerous times, and I just want to reiterate a couple of things. First of all, there has always been a claim that the cameras have increased safety in the city. However, what is never discussed is that the yellow light times and the all red phases were implemented at the same time the cameras were put in. So any claim of safety benefit has to be viewed within that context. And the LAPD has previously claimed that it's all due to the cameras, and of course, it can't be all due to the cameras. And in every place where the yellow lights have been lengthened, and you may see a news report that I had sent around to you, that violations plummet when you lengthen the yellow light times. The other thing to consider is in terms of the budget of this issue. One thing that is not discussed is the impact to the local economy. When you take millions of dollars out of the economy on these citations, most of which are for rolling right turns, you are seriously impacting the ability for businesses in the area to get business from their constituents. People sometimes can't even pay their rent when they get one of these $500 tickets. The other thing to consider is some of the things in the CLA's report, and that is that the suggestion that the LAPD would have to take over certain costs if this program were ended, and according to the contract, the vendor still has to provide a lot of those services even after the end of the contract, and that's specifically stated in the contract. I won't read it to you, but it's in there. And I see my time is up, but thank you very much, and I appreciate your time.
Thank you.
Hi, my name is Bose Adewusi. I'm with ATS California. Good afternoon, committee, members of the committee. I wanted to focus really just on the most important issue, which is public safety. The PD has already confirmed that the program has reduced a number of accidents, therefore reducing the cost of potential death and property losses to the city. A lot of hard work has actually been put into this program by the PD to make sure that the citizens of Los Angeles are kept safe from reckless red light runners. So there really should be no cost placed on safety or human life. Thank you.
Thank you.
Hi, Ray Pedroza with ATS California. A couple points I'd just like to make regarding the CLA report today. There are a couple numbers that are still in question on the report. First and foremost is the court reporter salary fund. I think there needs to be more discussion. Thank you. That although the city is considering terminating the program, the city will still be responsible for roughly $750,000 annually for the court reporter salary fund. It'll just be pulled out of a different traffic revenue program.
Speak right into that mic.
Sure.
Thank you.
And secondly, with regards to the ATS California continuing to provide services for the city, we are currently in negotiations with the city to continue on a month-to-month basis to provide support services for collections of these outstanding tickets. On a monthly basis, ATS California is responsible for handling approximately 2,000 customer touches, which means we answer telephone calls for the city. We process court evidence packages for the city in support of the police department to allow the police department to successfully defend these tickets in court. We also process affidavits of non-responsibility for the public, as well as associated correspondence for the city. So those are two numbers that I think require further discussion in the CLA report. Unless you have any questions.
Thank you very much.
Thank you.
Have staff come up. Good afternoon.
Good afternoon.
Now, your presentation is going to respond primarily to the motion that went forward, or do we have any additional information beyond the motion?
We responded to the portion of the motion that focused on the financial impact. The motion also asked for an analysis of the traffic safety component of the program. That is not something that we have done. I believe that DOT, if this program continues, would be in the position of completing that study and providing that report to the council.
And then would you just kind of walk us through with some of the findings?
I'll start with the financial impact. The motion had requested that we provide an informational report on a number of issues, one of which, of course, is the financial impact. We were able to obtain more updated data, and what we received from the court was revenue information between January through May of this calendar year, and based on that information, if the program were to continue, we project that the net revenue to be gained would be about $3.9 million. If we factored in contract and LAPD and DOT staff costs, the program would be at least cost neutral, and it's more likely that the city would gain additional revenue of approximately $200,000. If the program is terminated on August 1st, however, and allowed to phase out, we project that the city would continue receiving revenue over the current and next fiscal year, with 11 months contract payments avoided, adding the staff costs for equipment removal by DOT, and continuing LAPD and DOT staff costs to administer the program. There's a couple of scenarios that we have considered. One estimate is that for the current fiscal year and next fiscal year, the revenues to be gained would be approximately $1.7 million. Using a more conservative estimate, that would be reduced about $500,000, and for the 2 fiscal years, the net revenue would be about $1.3 million. We have to emphasize, however, as we indicated in the report, there were some transition costs for LAPD, which at the time that we wrote the report, we didn't have any information on. We asked the Information Technology Division of the LAPD to preliminarily evaluate what would be necessary to effect evidence data transfer from the vendor to the city, and the cost estimates that we provided in the report did not factor that in. We just received some very preliminary information from ITD about an hour ago. What they indicate is that transferring the data from the vendor to the city is really much more complicated than it appears on the surface. They would need some additional time in order to complete that analysis, and it may not be cost beneficial for the city to effect that data transfer because of the storage and also the more complicated technology requirements associated with that. That being the case, in order for us to phase out the program, an alternative that council may have to consider is extending the contract with ATS to allow them to maintain the data and to be able to provide that data to the LAPD so that they could use that evidence in court. Obviously, the other...
That's on tickets that have not been processed that are still in the system?
Correct. That would be all outstanding tickets as well as all tickets that would be issued as of the close of business on July 31st.
And then what the dollar value do we have on that? Or do we know?
Well, if we are assuming that there are approximately, on average, 333 court cases per month, then that would be, and apparently there's an 80% success rate with the LAPD going to court because the evidence is so clear. The revenue that would be gained from that would be approximately $42,000 per month.
Okay, but if that were not available, what would be the cost of extending the contract? What is the cost of extending the contract when you said we need this for evidence, and even if we stopped it, what would be the cost?
Well, I would have to go back to the comment that was made by one of, and I'm assuming he's with ATS California. He indicated that he was negotiating with LAPD. I saw a cost estimate for them to continue to provide the full range of what they term support services. I don't believe that the full range of support services is really necessary. I think that there needs to be negotiations with respect to focusing on just maintaining the data and providing that data to the LAPD on an as-needed basis. So I think that there needs to be a separate discussion that needs to be held with the vendor as to what those contract costs would be.
And then let me ask you, one of the items in the motion also, what is the status of the piece of legislation that I think went to ITGA? Has that motion or that committee report been approved by council, or?
Yes. Council approved the resolution on July the 13th with respect to amending the appropriate vehicle code section to require that the court transmit information to DMV for outstanding citations. My understanding, however, is that SB 29 has been referred to the suspense file in the Appropriations Committee because of the fiscal impact.
And then let me ask you, someone here from LADOT? Just like to clarify, we've heard in different testimony at different committees and council, have we experimented with the expanded yellow light or the four-way red lights throughout the city? And if we have, do you have any input as to what that has resulted in?
Can you please repeat that? I'm having a hard time hearing.
I'm sorry. That we've heard a lot of testimony about expanding the yellow light at intersections, and we've also heard testimony about creating a four-way red light at intersections. Mm-hmm. Have we experimented with either one of those or both? And if we have, what has been the results?
Okay. The LADOT currently operates our traffic signals with yellow time as well as all red clearance intervals that exceed the guidelines of the California Manual on Traffic Control Devices. We believe that what we have out there is sufficient in reducing the uncertainty that drivers tend to have when they enter the dilemma zone as to there's a certain zone in advance of the intersection where the driver is uncertain whether they should stop or proceed. And the purpose of the yellow light is to give them adequate time to react and then brake in time to stop or to continue to proceed and still make it through the intersection legally. The all red clearance is there so that in case they enter at the very end of the yellow, there will still be sufficient time for them to clear the intersection before the conflicting traffic begins to approach and enter the intersection. Because we operate our signals with this additional, more generous timing, we find it we are finding it difficult to figure out how much more time we're supposed to give them. I know that there had been testimony in council that says that if you added an extra second of yellow time then you will see a dramatic drop in violations immediately. However, what is not certain is in other cities where they have done this, how much or how many intersections have they done it to? How did they review their data, and had there been sufficient yellow time to begin with? It could be that that yellow time was added on after operating the signal at a deficient yellow time.
But
So-
let me ask you, what is the average yellow time that we have on signals? And is it universal throughout the city?
It's based upon a formula. However, for the 32 intersections, which are very similar to other intersections in the city where you have a speed limit of typically 35 miles per hour, the yellow time is approximately 3.9 seconds.
3 point what?
Pardon me? 3.9 seconds.
3.9.
Yes.
Is that universal citywide?
It is where you have a speed limit of 35 miles per hour.
Okay. All right. If it's higher than 35, what?
Then the yellow time would be adjusted upward accordingly to.
Standard there?
There is a standard equation, a standard table that we utilize from the California MUTCD.
Okay, so this is driven by what, state law?
Yes.
Okay. Do we have access to that table that shows if it's 35 and it jumps to 45, what the yellow light expansion is? And again, is it consistent throughout the entire city based on the speed limit?
I cannot say that it's 100% consistent, but it is our standard as well. And as we complete our upgrading of our traffic signal systems, as we review each intersection that we upgrade, we also, of course, look at the signal timing and upgrade that. But I cannot say it is 100%, but it is our standard.
Does it ever drop below 3.9 even if the speed limit is below 35?
It is possible. There's some isolated intersections that have not been updated in the recent years that may encounter a shorter than standard yellow.
What about the four-way reds? Have we experimented with that?
My answer would be similar for the all-way red situation. The all-way red is, again, also based on a standard equation that we use, but it is based upon, again, the speed limit and also the width of the intersection. So, therefore, as we review each intersection, as we upgrade the signal design for each intersection in part of our ATSAC or ATCS programs, we will, if we haven't already, update the all red clearance time as well.
Then how many signal-controlled intersections do we have?
I think we have over 4,500, about 4,500.
4,500.
Mm-hmm.
Of those, if we went backwards, what percentage would you say we have four-way reds?
I do not have that information with me. But I can get
What are the criteria that you said that you use for four-way red?
It's based upon, the equation is based upon the width of the intersection and the the speed limit plus 5 miles per hour.
Yeah, just a couple things. And I guess what's before us is really the issue of whether we're going to extend the contract yet again or not. In looking at this, first of all, I want to say that I want to compliment the report because I think it was really difficult. This has been an extremely complicated issue that a lot of people have been weighing in on this citywide, and a lot of neighborhood councils and local leaders and stakeholders. And to put this report together was I could only look at it and guess that it was difficult at best, and it really did a great job, I think, at analyzing all the different scenarios. I think at the end of the day, everybody supports reducing fatalities and reducing injuries and pedestrian safety, and looking at really what the cost is of all those elements. In looking at this and based on the report, there appears to be I'm go on the record and back up and say that I'm absolutely opposed to the current system the way it works right now, but it wasn't the current vendor that installed the system as well, from my understanding. They inherited the system through a bankruptcy, is that correct? And they assumed the contract?
Correct.
Yes. And I remember when this contract did come through originally, it was extremely controversial at the time. And at the time, my boss then, Councilman Smith, did not support. He supported the photo red light system in concept, but not the way that the proposal was written. And I understand in that there was an audit that was done of the current system, and the audit, the controller's audit, identified many issues in the current system that were addressed in a new RFP that apparently this is the issue, that the RFP was not released out of the police commission. Is that correct?
There was an RFP that was released by the department. There was a recommendation for contract award.
Okay.
The police commission decided not to move that to the council.
Right. So that's what's still not technically pending, but that wasn't moved to the council, was the new RFP where these issues from the controller's office were addressed. So in looking at expanding or extending again this contract, which originally, quite frankly, before reading this report, I was all for ending the contract based on the fact of that it has a lot of issues, not so much the company itself, but what they inherited and what was installed. And but in looking at the report, it looks like there could be an argument, or there's certainly an argument, that I could support at least extending the support services for the contract, because according to this report, there's a cost of, well, it says here under scenario 3, it could be an adjusted net revenue, this is on page 4, of $85,413, and I'm assuming on that scenario that has to do with the collections at the 60% rate of all outstanding citations, and of which there are currently about 65,000 outstanding citations. Is that correct?
Correct. There are 65 1,000 outstanding citations from the inception of the program beginning in 2006 through May of this calendar year. Let me emphasize, however, that 75% of those are between 2009 and May of 2011.
Okay. And then there's an additional cost for contract cost avoidance here that, and I'm not sure if that's actually part of scenario 3 or not. And I'm going on scenario 3 because it's the conservative estimate that you put together. And I always lean towards a conservative estimate, and it would look like it took scenario 1 and 2 into account. But I'm not sure if that included the equipment removal after scenario 3.
Let me just clarify, Councilman. What you're looking at is assuming that the program is going to continue with the current contract terms. So the issue of the equipment removal would be assuming that the program was going to end.
Right, but at some point it's going to end in the existing equipment no matter what, whether it's going to be on August 1st or after scenario 3. At some point the equipment would have to be removed, I'm assuming.
Right, but in looking at that table, the 3 scenarios there is assuming that the contract is going to continue through the end of the fiscal year, and that's where the revenues come into play.
Right, so I guess my question is that under scenario 3 does not include, at the end of scenario 3, the contract equipment removal. Is that correct?
Right.
Okay. I'm also going to assume, and that's why I want to ask the question, because I don't want to assume, that scenario 3 does not also, at the end of that period of time, under scenario 3, there still will be some outstanding citations that hadn't either gone to court yet or were not collected.
Correct.
And that information for us to continue to go to court or go to appeals or try to collect the money or utilize our collection services, all of those scenarios, with that, we still will not have, once the contract's ended, access to the data and the information on the vendor's database under scenario 3? Once scenario 3 is over and there's still outstanding citations and we want to continue to collect those or go to court, will we have access at that point? Does it transfer over at the end of the contract to our databases?
We would have to amend the contract to more clearly define exactly what would happen under that circumstance. The way that the contract is currently worded, as of August 1st.
Okay.
The cameras are turned off, the processing ends, whatever pictures are captured during that period of time is going to stay with ATS. We need to find a mechanism within which to allow LAPD to be able to access that data. The way that the contract is worded does not allow for that. Given the current contract costs, we would have to pay for that.
Now, and the DOT, just to, if we ended the contract, and I'm just trying to get these facts down, it says here in the report on page 5, at the top of page 5, that it's estimated to be at cash overtime $155,000 to remove the equipment. Is that correct?
Mm-hmm. It's to remove the infrastructure that was installed purely for the photo red light program.
To remove the infrastructure?
Mm-hmm.
Now, from my research, I couldn't find another city where, well, let me ask it instead. I'll ask the question. Were there other cities that actually DOT performed the installation and or removal of photo red light equipment, or how is that normally done with a photo red light vendor?
I don't know the specifics of how they handle photo red light equipment. However, I do know that many of our neighboring cities contract out the signal construction and signal maintenance work.
I'm not talking about the signal. I'm talking about the photo red light equipment itself.
Okay.
Is that usually installed by, from my research, it's usually installed. I'm just trying to verify this, if this is correct or accurate, and making sure that staff would give me information that's accurate as well. What's the normal course of action? Is it the vendor, the photo red light vendor, that actually installs and then after the end of the contract removes that equipment?
My guess is that currently that most contracts equipment is installed by the contractor.
By the contractor?
Right. But with this particular contract, however, which started with Nestor, an arrangement was made before the execution of agreement that in the agreement DOT elected to install the infrastructure and then have the contractor supply the unique equipment that otherwise DOT would not have in our possession. So that would include camera poles, the camera brackets, the cables, the strobe lights, and the controller cabinet. And then on top of that, the contractor would then be allowed to install their cameras on top of the camera brackets, as well as the computer, the controller, in the controller cabinet.
So all the hardware and installation of the hardware was done, not necessarily the cameras or software, but the poles and the cabinets, those were all installed by DOT.
Correct.
And I guess I was making the argument or asking the questions, trying to come to an answer of the removal based on the installation, that the city of LA is the only city, from my understanding, that has had this equipment that actually performed its own installation.
Right, because we are also in a unique position where we do have, and we did have, a significant traffic signal construction crew, and that because we're familiar with our equipment, a decision was made early on that we would rather and elect to install the equipment and bypass all the permitting and so on that the.
But now it says here the DOT is reporting back that the department is so severely short-staffed, it says here on page 4, that we would be determined to lose high-priority projects, including ARA-funded projects that are underway, that this would set us back and that we would have to pay cash overtime for the removal. And I don't know if the vendor has been approached. It sounds like there's got to be some type of compromise that if we actually end this contract on August 1st, not only could we jeopardize losing 65,000 citations that had been issued in the revenue according to cost neutrality in the contract that are associated with those, but we don't have even access to the data, to the video information. We don't have the DOT personnel to, and I'm assuming once we rip the equipment out, we'd have big holes in the concrete that has to be patched and paved, and
yes.
Okay, that we don't have the personnel to do that according to this as well, and that there seems to be issues also with the actual devices themselves now. So I'm not sure what we've done to negotiate trying to phase this out where it's reasonable, where there's something that we still have access to all the information we need, where perhaps the vendor would be willing to work on removing the equipment, so we're not paying out $155,000, and those are taxpayer funds. So that's, I don't believe, was the $155,000 part of this current year's budget, fiscal?
No.
Budget? So that's new money as well. I've got to believe that the vendor, it sounds like the bigger fish ate the smaller fish in this case. The ATS bought the smaller company out of bankruptcy. They probably have the knowledge and experience to remove equipment, that they may be willing to do it by some kind of phase out. And then looking at the issues in the existing RFP that had met the controller's audit, if those issues, and I don't know what those have been, if they've been resolved in the RFP, the pending resolution of the court notification and DMV issues, the reduction of the excessive fine system, I know those were all addressed before the new RFP went out, and I know this isn't a meeting on the current RFP, so we can't discuss those things, but those are issues I think need to be vetted so the public can hear that as well, because those were the real concerns. My concern is that if we end it right away, which I was about to walk in and support until I read the report, it sounds like there's some good arguments to be made to try to phase out and to protect the public on this, as well as the city, the program, if the contractor is willing to work with us on that. Is there anybody from ATS that could respond to that? ATS California, this is what they're calling themselves. And I don't know if it's a 6-month or a 1 year. I mean, I don't know what it would take to make sure we had access to all the data, to make sure that we can respond to 65,000 citations, to remove this type of equipment that we clearly have not funded for, and the DOT does not have personnel. My concern, we lose programs and ARA funding that we've got ongoing, all these things that are stirring. Have you been approached or talked to?
Yeah,
about those?
we provided a proposal to the city to continue providing what we call back office processing on a month-to-month basis. The proposal did not include, though, the removal of the hardware. That pricing was not included. And like was mentioned, DOT did install all of the infrastructure. Our cameras are sitting within the infrastructure, and we will, of course, pull our cameras from the infrastructure. But we did not provide a cost proposal to the city on what the cost would be for ATS California to remove that infrastructure. So.
And have you had the experience in installing and removing equipment in other large cities?
Most of the experience is installing. Very infrequently are we removing equipment. So this is a very unique situation. But I think one of the questions that was asked earlier was, are there any cities that install and remove the equipment on behalf of the vendor? Outside of the city of Los Angeles, I cannot think of one big city, at least, where the city was responsible for installing the hardware. To this date, there has not been a big city nationally to remove or terminate a program that I could think of right now.
Okay.
Can I just offer some historical information?
Let me ask you to do one favor. I forgot to ask when you came up. Just both of you identify yourselves for the record.
June Gibson with the CLA.
And Pauline Chan from the Department of Transportation.
I just wanted to offer some historical information, if I recall correctly. When this issue was originally presented to council relative to the construction component, my recollection was that the unions did raise some concerns about contracting out bargaining unit work. And I believe that that was an important consideration on the part of council to decide that the construction was going to be done by city staff.
Okay, thank you. I wasn't here then. So.
Thank you. I understand we're here because the council wasn't sure which direction it was going to go, and it got bounced back and forth. I have one simple issue, and my issue is whether the ATS is an Arizona-based company. The city attorney has stated in their opinion that they believe that ATS is an Arizona-based company. Although we don't have our ordinance drafted or approved by the city council, the CLA does point out that past practice with regard to implementing the city's social policies and ordinances has been to look to the true ownership and management of the company with whom the city is considering doing business to evaluate whether the contractor is in compliance with the city policy or ordinance. And here the CLA states that given that analysis, ATS does qualify as an Arizona-based company. So for me, this conversation's moot. I'm not even sure why we're deciding to move forward. I know we don't have an ordinance. However, past practice has not allowed the city to do business with companies once it has declared a boycott on similar circumstances. So I cannot support this at this time.
Just a couple of financial questions. Can you tell me, this is right, CLA, you outlined two scenarios for the committee's consideration. Termination by August 1, no phase-out plan. This would have a negative financial impact to the city. True or false?
That's true.
Phasing out the program beginning August 1st, this could result in a positive budget impact of 1.5.
Correct.
That is correct.
The number, obviously may vary because we don't have all of the associated costs, with phasing down the program, but it will be a positive result.
If we phase it out, we bring in $1.5 million. If we don't phase it out, it costs us money. Do you know what kind of money that we're talking about in that cost?
In terms of the transition costs and the potential additional contract costs?
If we just terminate it by August 1 with no phase-out plan.
Yeah, our calculation is that we would lose at least $200,000.
Okay, so we lose $200,000 if we don't, and we get $1.5 million if we phase it out. Roughly.
Roughly.
And what time frame are you talking about phasing it out?
This was assuming that we would keep the program in place with the assumption that the data transfer would be affected and that the data would be readily available to LAPD until the program is completely over and done with.
Have we talked to the vendor about the alleged 65,000 or 60,000 that exist, and can we get access to it, and can we deal with it?
I believe there has been references made to discussions with the LAPD about the transition costs and to be able to continue the contract for what was termed to be back office support. I think, as I indicated earlier, I think further discussion need to be held with the vendor as to the itemization of the proposal that has been offered. I don't believe that all of those tasks are necessary.
You're the vendor.
Yes.
So what do you say to what she just said, and what's the time frame? What kind of monies are we looking at? That kind of
Well, from a time frame perspective, I mean, we're ready to offer the city continued back-end services. If the city is wishing to terminate the program permanently on August 1st, we can provide the data to the city. Should you not want to continue on a month-to-month basis, we can provide the data to the city in some form of electronic media, and the city would be responsible for taking that data and establishing their databases and processing the data.
Okay, thank you for that. DOT, I don't know if you got that answer for this or not, Pauline, but I've heard a million different ways to Sunday, either extend the yellow or extend the red. If you extend the red in all four corners, or if you extend the yellow. I've had a mayor from Yorba Linda, Loma Linda, get up and say, all we did was continue the yellow light and the issue was gone. I've had experts come to me and say, if you just keep it red or yellow, it will work. What is our determination on that from a safety standpoint and from this issue?
I think that there is no magic bullet. Ultimately, running the red and red light enforcement, running the red light is a safety problem, and there's a focus on it because of the severe injuries and potential fatalities that it causes. There are a lot of research being cited, and if you really bother to read the research material, if you all bother to do that, then you will find that it is not exactly conclusive one way or the other. However, you will see research say, yes, there is a need for cities to follow certain guidelines to make sure that there's adequate yellow, and that adding yellow would be very effective, especially in cases where the yellow is insufficient to begin with. And many of these studies have been done in the 2000s, 2004, 2005, and back then there are cities that the cities that were examined may not have had enough yellow time to begin with. And so the federal FHWA recommendation is that cities should follow these guidelines. These studies will also further tell you that although there is an effective outcome for extending the yellow, that does not take away the need to continue having photo red light enforcement as a tool. And at the end of most of these reports, they will basically say more research is needed to draw any very definite conclusions. One problem I have with some of these studies is that the data, the sample size for the data is very small. And that is why, and in many of these cities, we do not all use the same guidelines in terms of how we evaluate effectiveness. So I think that had there been some consistency, and had there been more data samples, and had there been more research done in terms of more long-term examination of continuing behavior and collision analysis, collision statistics, then we can more safely say that, yes, this is a definite solution, or no, this is not. but I don't think that the data and the research is conclusive.
Okay, saying that, but I mean, just instinctually, at least from where I come from, if I got a red light, for the most part, I never would go through a red light. I might have a problem with the yellow light. People sometimes speed up and to get there before the red comes and so on and so forth. But if you had them all red for a period of time, that seems to me, to be candid about it, is a no-brainer in terms of everybody stopping and dealing with it.
Absolutely, and that is what we already do.
I mean, but on those 35 intersections.
Oh, no, it's throughout the city. I just couldn't tell you exactly what percentage of of all the traffic, 4,500 or so traffic.
I understand that. But what about the 35? The ones that we put this high-tech new thing in there, have we attempted to let those reds stay longer and those yellows stay longer and just have empirical data on 35 lights?
Yes, there is, the RRED interval has been implemented at these 32 as with many intersections in the city. So the RRED is already in place. And the way in which we...
Yeah, no, but are they long enough so that a person can feel that energy of that red light and not get in trouble over it?
I've driven some of these intersections, and as many intersections in the city, and I do see the positive effects of the RRED interval in how it helps prevent collisions. We also, of course, as I had said earlier in the meeting, that we are following the guidelines that are recommended by the California MUTCD, and in fact, where we're told to use the speed limit as a way of calculating that actual time, we go beyond that and we add another additional 5 miles per hour above the speed limit in the calculation, in the equation.
So those 35, we have done that too?
At 32, we have done that,
32.
as we have it at all of the intersections that we have upgraded in the city of Los Angeles.
This went before the police commission, is that correct? And they decided to stop it. Now, we've never had a commissioner explain to us why, but we've asked for that. Is there a commissioner in the room? There's no commissioner in the room, but we have the staff man. All right, come on in. Explain to us why the commission unanimously took that position to discontinue it.
The position of the commission, Richard Fank, Executive Director of the Board of Police Commissioners. The commission's decision was based on the RFP that had been released and a recommendation from the department to approve the RFP and to forward it to council. The commission's decision was on the RFP. The contract extension piece that you are looking at now, separate from the RFP, because the RFP is not on the agenda, I don't think I can speak to that specifically, but I will tell you the 4 issues that came up as to their decision. The contract extension before you, when it came to commission, the commission authorized and recommended a 90-day extension of the existing contract, which got it to July 31, pending the department bringing forward the RFP. The 4 issues that the commission is considered, and not in this order, but I will give them to you in this order because I think the first one is really relevant to this discussion. It is the fact that currently in Los Angeles County, the Superior Court has made the decision that the payment of a photo red light ticket is a voluntary payment program. And that is that if you receive that citation in the mail and choose to tear it up or do nothing with it, there is no action, no sanction that is taken against you for payment of that. So as you look at the revenue assumptions of the 65,000 tickets that are out there, you have to make the assumption that although 60% have been paid through the month of May of this year, the publicity that has been generated in the past few months about this program, anyone who pays a photo red light ticket in any of the 26 cities in the county of Los Angeles is not paying attention to the news.
Aren't we still sending it to collections, though?
They are going
to... It's not DMV not being notified, is that correct?
If I can explain that, sir. They're going to collections, but they're not going to collections to go on your credit report or to go in any other manner that is derogatory to you. They are forwarded to collections to say you have a bill, you owe the county of Los Angeles, but the county of Los Angeles does not forward that to a collection agency and therefore go on your credit report.
So, wait a minute. If that's right, then your comment about the money outstanding and then his ability to say would forward that data to you, does that take that $1.5 million away in your mind, or does it still leave it there?
I did contact the court to determine what the collection rate was. They're still investigating that information. That is true, that the information is not forwarded to a collection agency if you don't pay, if you don't pay, and I did ask the rationale for that, and sort of similar to the rationale of the court as to why they don't transmit the information to the DMV, and the rationale is on the basis of what they deem to be what they consider fairness, and their view is that if an individual does end up paying, they do not want their credit to be negatively impacted by virtue of them paying.
So the bottom line is there's no hammer.
I don't disagree with that.
Okay. Your second point.
The second point is the deficit that was in the program. The third point was the potential impacts of Senate Bill 29, which the CLA has addressed. And the last point was in consideration of the Arizona boycott issue. Those are the four main points. But number one in the commission's discussion was this is a voluntary pay program. There is no consequences for the issuance of a photo red light ticket and failure to pay. Different from a police officer who issues a citation in a traffic stop, that you then, if you do not pay the citation, a warrant for your arrest is issued, a separate violation. When you go to renew your driver's license, at that point in time, you'll have to deal with that citation in the court unless you're stopped also and get arrested on a warrant. So there is a sanction to that piece. There is no sanction to the current status of an LA County.
Thank you very much for that. I appreciate it.
The one thing, though, just for clarification, and that's how I read the report as well, and assumed as much, in fact, that it wasn't going, the collection part of it, there was nothing going on anybody's credit report. So thanks for that clarification on that as well. But the scenario 3 also was a conservative estimate. I assumed that this was based on the lower collection rates as well. This was a conservative estimate. I mean, it goes from, on the scenario 3, again on page 4, to adjusted net revenue of $85,000, all the way from the original scenario 1 of $242,000, a significant difference.
Scenario 3 is frankly just an averaging of the revenue between scenario 1 and scenario 2. Scenario 1 revenues was based on 2010 data. Scenario 2 was based on more updated revenue information from the current calendar year. So scenario 3 is just an averaging of the revenues for those two columns.
And does anybody know where we're at with the state situation on fixing the court problem as it stands right now?
Remember, they moved that legislation to suspense.
Which would mean that we probably would have to go and include that component as part of next year's legislative program.
Mr. Chair, can I get a word on edgewise here? Everyone else has had their opportunity. I have a lot of questions. Here. The most obvious new one to me is the idea that we would have to assume the costs of ending this contract. My reading, according to the contract regarding assuming the functions for the 65,000 outstanding citations, etc., is that the contract would show that the cost should not be borne by the city. The wording of it, and I don't have the actual contract, I just have this in my notes, quote, at the conclusion of this agreement, contractor shall complete all program work associated with the final violation images captured by the system on the last day of the agreement. Such work shall include but not be limited to citation processing, citation approval procedures, violation viewings, preparation of court case packages, and court appearances as identified in Appendix B. My reading of that would be that this is not our cost to be borne, this is the contractor's cost to be borne as they exit the contract. I'm not sure whether a city attorney or someone else should be answering that question, but it certainly doesn't sound like, unless I'm missing a piece of this that we should be on the hook for this. The contractor should be on the hook for it.
Good afternoon, everyone. My name is Terry Martin Brown. I'm an assistant city attorney, and I advise LAPD on contractual matters. Councilmember Koretz has pointed out Section 20 of the contract, which talks about what would happen at the conclusion of this agreement. And just for your reference, the short paragraph, which I'd like to read to you. At the conclusion of this agreement, contractors shall complete all program work associated with the final violation images captured by the system on the last day of the agreement, which in this case would be July 31st. Such work shall include, but not be limited to, citation processing, citation approval procedures, violation viewings, preparation of court case packages, and court appearances, as identified in Appendix B. Appendix B is a document which is a statement of work. And it goes through each of those categories, which I just indicated, for example, citation processing. In detail, it talks about what is involved in the citation processing. And those would be things like the contractor or the vendor would electronically interface with the Department of Motor Vehicles to determine the registered owner's information. The contractor shall maintain a chain of custody for all documents relating to the operation of the program. A quality check of each violation shall be conducted by contractor. Contractor shall print all traffic citations, assume all mailing and postage costs, process the digital video images of each violation, and the like. And those descriptions go on for pages. Currently, under the contract, the contractor is paid a monthly flat fee of $8,000+. And that's to maintain the equipment, the cameras, and all that is involved in the citation processing. So obviously, assuming that these court cases and appearances might go on, be continued for a year, year and a half, following the last day of this agreement, that's quite a bit of work. I think we could assume that the language of this contract, I think it would be a very reasonable interpretation, and it is certainly my office's opinion that the contract means the contractor would continue to be paid for those support services or closeout services or phase-out services on a monthly basis, and perhaps not in the amount of $8,000+. I think that would be unreasonable because they would be doing less work. But I think that that payment cost should be negotiated between LAPD, DOT, and the current contractor, ATS, for the performance of that work.
What would lead you to interpret that way, especially since it says they shall complete it? So it means they don't really have a choice, they have to complete it. What in there makes you think that that wouldn't just be part of the past contract?
Well, I think the monthly fee
obligation
indicated in Section 5, which deals with compensation and payment, talks about this $8,000 plus fee per intersection for each of the 32 intersections. And that is paid, ATS and the previous contractor invoice the city on a monthly basis for those services. If the services continue, some sort of monthly payment continues. And I think the city has a legitimate argument in saying, and I think the contractor would certainly agree, that there is some payment less than $8,000 plus a month that would be reasonable. We can't expect them. It would be unfair. I don't think any court would go along with the suggestion or notion that the city should not pay for services that are received.
But one could assume that the value of the whole contract during that period would have included this function of cleaning up after the contract. So I don't even know how long that original contract was. Let's say it was for 3 years. One could assume the profit that was built into it included the cost of cleaning up after the fact.
Well, I think if we read the entire contract and we note that there is that monthly flat fee of $8,000+, and that is for certain services, and we would pay that on a monthly basis per intersection, and there's a performance guarantee built into the contract, and if the contractor was not meeting that performance guarantee, then the city was entitled to withhold certain payments. I think all of those very clear payment terms indicate that the contractor is to be paid on a monthly basis for a certain level of services that are performed. And so we are not paying just a flat fee of $1 million a year, and you perform all of these X, Y, and Z services. The services are very specific. They are on a monthly basis, and they are dependent upon the contractor's performance at a certain level.
So is it possible that we really didn't anticipate ending this contract and not using red light cameras anymore? Because you would think there would be an amount for just continuing those services if we actually were anticipating terminating a contract. Because obviously the $8,000 is more than the cost of the ongoing services.
Well, that's why I'm stating that there is a strong argument, both legally and just as a practical matter, that the services, the support services or closeout services or phase-out services, however we want to term them, are not worth the $8,000 plus flat fee indicated in the contract. But certainly the contractor, as any contractor would be who performs the services in a satisfactory manner, is entitled to adequate and reasonable compensation for their work.
And is this your position or the position of the city attorney's office?
Well, as a representative of the city attorney's office.
I mean, is this your reading, or have you talked with the city attorney about this?
Do you mean Carmen Trutanich, the
Yes.
city attorney?
Yes.
No, I have not talked with him personally about this.
Because it sounds like an issue that certainly has more than one side, and I think I for one would like the actual city attorney's opinion on that, and to have him review that. Let's see. There's certainly a question on the motion that we made in council, and that we passed unanimously 12-0 to increase timing of yellow and red light cameras. I know you've said you're fine with the present timing, although we've suggested that we do what has been tried in some other cities and adding further. The most recent example that I'm aware of is in Arnold, Missouri, where they went from 4 seconds to 5.6 seconds of yellow, and they found that they had a drop of 72% in their tickets within a few months. We suggested that we add both some yellow timing and some red timing. You basically said that you think it's fine the way it is. So my sense is that somewhat in insubordination, DOT has decided not to move forward with the direction of the council. Is that a correct assumption, or are you actually planning on adding yellow and red light timing as we suggested in that motion? And what's the timetable for that, if that's going to happen?
Actually, we do not intend to subordinate in any way. I think that we just have simply not executed in accordance with that motion. I think we also expected to see what was the outcome of the current, whether it will be extended, because, and also because we were awaiting for that item to be agendized in committee. But we were preparing in case it did become on the agenda of a committee, so we can proceed.
I wasn't aware that this had to go to committee after a 12-0 motion passed at the council level.
Okay, then it's
I
it's our
didn't hear anything that
misunderstanding.
directed that something come before committee first. It was instruction to do it.
Okay, we can proceed with that.
And there's nothing about whether red light cameras are on or off that would change the impact. It was done in Loma Linda in the intersections that already had red light cameras. They added to the timing, and they had a 90% drop in citations because the timing solved the safety problem, which is the whole point. So what would your timetable be that you would expect before the signalized intersections that have red light cameras have the timing changed?
I think we can do it within 2 weeks or so. I do want to make a comment, however, that the stated goal of the photo red light program is to reduce collisions. And perhaps to some degree, a lowering in violations could result in reduction of the collision rate. However, what is not known and what needs to be studied is, and there's inadequate research on this issue, is how long would the effects, the reduction effects on violation persist, and whether that level of reduced level could continue indefinitely, so that there would be no need for, additional forms of enforcement.
I mean, intuitively, as Mr. Rosendahl had noted, I think the idea that people would get used to it and they would start running red lights and leaving early, I think, is very unlikely. So I think intuitively it could almost not fail to have an impact. If you added a second to red lights in all 4 directions, it's almost impossible for me to understand how that could fail to eliminate most collisions that a red light camera itself could halt. Obviously, if someone's not paying attention, they drive through the middle of a red light, you can't do anything to stop that, but the camera wouldn't do it either.
Well, I think that I guess that I was trying to explain here in committee that DOT already operates or signal with extended yellow and extended all red intervals. Certainly adding additional seconds should result in some immediate reduction in the number of violations. But the question again still is, would it have long-term effects, or would drivers become habituated? Another question I would have moving forward on this is that once the cameras are shut off at the end of July, there really is no way of measuring the effectiveness of the reduction in violations, because we would not have the equipment to witness the violations. So it would be very difficult for us to conduct such a study without that tool, the cameras themselves.
That would be true. That would be true. Now, why do we actually have to remove the equipment? Who owns the equipment?
The camera poles, the camera brackets, the strobe lights, the cables, the controller, which is the computer, as well as the cameras, have been supplied to the city by the vendor, and then the city took that equipment and installed it, with the exception of the camera and the controller, which the vendor installed in the field themselves.
So the vendor owns all the equipment?
Yes.
What would happen if we didn't remove it?
Well, the vendor has, in their proposal, requested that we do return the equipment. So I do not know what the consequence of not returning would be, if we have to compensate them in any way. Secondly,
or if we just required them to pick it up themselves.
Well, we can certainly
According to my read, although again I think it's not universally agreed to, is that cleaning up after the fact is the responsibility of the contractor. So I would think picking up their equipment, according to my read of the contract, would be their responsibility as well.
The contract clearly says that the equipment is going to be returned to the vendor because the equipment belongs to them. My understanding also, in terms of the itemization of the tasks to be performed, the vendor is going to be picking up their own equipment. The DOT costs are associated with the infrastructure component and sort of undoing what they had actually done, specifically putting the poles into the sidewalk. So now we've got to do the reverse of that. They now have to take the poles out of the sidewalk, and then they've got to obviously pave over the sidewalk so that there's not going to be liability to the pedestrians that are going to be walking in that area. So there is a division of labor that's already been identified.
But we're assuming we're responsible for the removal of the equipment.
Well, we're going to be removing the poles. upon which the equipment is installed.
And those are theirs also?
Excuse me?
The poles are theirs as well?
Yes. May I add that the contract specifies that any equipment owned and provided by the contractor or one of its subcontractors, including but not limited to cameras, poles, housing cabinets, signs, and computer workstations, will be returned to the contractor. But the same paragraph on equipment, Section 15, states, all equipment owned and installed by the city shall likewise remain in the city's possession and ownership and shall remain with the city.
Okay, and another question, have we calculated at all, I know this was touched on, what's likely to happen in terms of continuing reduction in payment of tickets as we continue to publicize more and more the fact that you don't have to pay them? I assume there'll be, articles in the LA Times and the Daily News, on this hearing. Every time that happens, more people realize they don't have to pay. So at the end of the day, don't we wind up close to nothing? And certainly, would it not make sense to not continue to dig ourselves in a deeper and deeper hole fiscally by not continuing the full contract at least?
I don't think that there's been enough of a lag time from the time that the publicity with regard to this being a voluntary program has been made public. I agree with you. The more often we talk about it, the more people are going to know. But the trend has been that the number of citations that have been issued and the revenue that we've been receiving, certainly between January and May, has been increasing over the previous year.
So people are still paying?
People are still paying, and a component of that is that more citations are issued the current calendar year than in the past.
Okay, I want to make a motion that we terminate the contract. Well, I just want a motion on that, and second.
Hey, I'll second that.
Okay, please.
You finish your question?
Yeah, I think for now I'm fine.
Let me ask June on the issue of the current process. What's the percentage of citations that we're collecting on now?
My understanding is that the rate is about 64%.
Okay. And then let me ask the police department if you could come up just a couple of questions. Yes, Mr. Keefank, could you just respond? And I realize it's not on the agenda, but if you could educate us, is there anything in the new RFPs that the commission reviewed and the police department recommended that is a different operational circumstance than what's currently in place?
I don't believe so, sir.
So is the same companies a part of that?
The
RFP?
RFP that came to the commission, the recommended vendor was the current vendor.
Current vendor.
And I believe there could have been some cleanup of items that were earlier spoken about that were identified in the first contract that needed to be addressed that were in there. But I believe operationally, from how the department would process citations, et cetera, that it was contemporary with what we have today. The equipment could be more modern, et cetera. I can't recall specifically.
And then let me ask you, one of the elements you mentioned from the commission of the issue of the Arizona issue.
Yes, sir.
Was there any discussion as to what the commission and department's going to do when it's time to buy tasers, which come from Arizona, and it's the only place you can buy them? What is the department going to do?
There was no discussion about that, sir.
Hopefully, we're not going to stop buying them.
I would hope not.
Okay. All right. So the thing is that that's contemplated because we have to renew them, and that's the only place, if I understood when we did the contract, that you can currently purchase them.
That is correct.
Okay. And then the other side of it, I just want to clarify, that you mentioned, and I don't want you to speak on behalf of the chief, but the chief of police had a different recommendation than the commission.
That's correct, sir.
Okay. And he recommended that we move forward.
Yes, sir.
And then let me ask the CLA just a final question. If we talk about the $1.5 million, when we calculate that, how does that reconcile with the issue of the $3 million plus hold that will be generated if we don't get the revenue?
What we took into consideration in arriving at the phase down was that we were assuming a 1-month payment for the contract, and that's about $256,000. So there would be cost avoidance for the remaining 11 months. So that's where the significant cost savings would come into play.
I'm sorry.
Should I repeat myself, sir?
I was harassing him. Give me that
That's what I
again.
get for being the rookie. Hazing.
There would be a cost avoidance of $2.5 million because we would only be paying for the first month of the contract, given the fact that we would be terminating as of August 1st.
Mhm.
So that's where the significant savings would come into play. So on page 5, we itemized where the cost elements would occur.
Colleagues, any other questions?
Actually, I'd like to make a substitute motion that we hold this item in committee for 30 days, and we clear up all the contractual loose ends and get an opinion from the city attorney on what we are and are not responsible for.
Let me, you got a second?
Well, I just point of order. The end of this month of July, it terminates. Is that correct?
Well, the issue is that it does by contract, and that's one of the reasons that we wanted to get it on committee today and audits tomorrow in order to get it before council, believing that we should make a decision before it terminates instead of just letting it flow. And that's what the whole purpose of trying to get this before 2 committees with a judgment that the council could make about the circumstance.
Yeah, but if we agree as a majority of the committee that we want all these answers answered, it would automatically kill it, which is frankly the direction that
then we should just say kill it.
Well,
We shouldn't
I
play
have
like we kill
that
it.
motion in there for that.
I mean, that's the whole thing of bringing something to the council for the full council to review.
Yeah, but when
We
the
never
full
did.
council reviews it, you're going to have that information. Why we haven't extended the red light like we had said, or the yellow light like we have said, to prove that point. We're only talking 32 intersections, you know. It's not like all 4,500 of them in the city. And that's one big issue. And secondly, I don't want to play politics on this anymore. We've politicized it beyond where I even want to go. That's why I'd like us to terminate it. But if it means we're going to put it before the council, you know, we have a couple of days left. We have a full council meeting Friday on AEG. I just don't know how you do it on Friday as an afterthought, and then the end of the month is that weekend. I'm just wanting to be straight about
Point of
this.
clarification.
Let me just ask one thing
Mr. Chair?
let me just one thing clarify.
That's all.
On one thing on clarity, do we have time for a special on Wednesday from this committee?
Council. We do a Wednesday special.
Does anybody have a timing? Do we have the ability to do a special?
The council president will have to approve a Wednesday special.
Council or committee?
Point of clarification.
Or council. Or council, so you can get it Wednesday to ask your question as opposed to Friday.
Yeah, but I mean, they won't have any of those answers we've asked for in the context of it.
They won't be
It'll
able
just
to
pure
implement,
politics.
they won't be able to implement the extra seconds, true.
Right.
If I could clarify something, is your motion to move it to council, or is it to receive and file this report? How would you
My
like to vote in
motion
opposition?
is to terminate it and receive and file it, so it doesn't go to council.
Well, I will second that with that clarification as well.
Well, I won't support that. I think it has to go to council because it was a council action.
It's going to another committee as well.
Plus it's going to another committee.
If I could counter that motion then, and look at, there are some significant costs, I think, that were brought up in this report and brought up in committee. Significant costs, support services, cost avoidance of potentially $2.5 million. We still have the issue of equipment removal. There's still the issue of $65,000 citations that are still out there, whether it's a voluntary system or not. Those are significant dollars that were not budgeted, from my understanding. So my counter motion would be to send it to council and negotiate an extension with the phase-out support services, and to figure out what those elements would be.
Second.
No, you're seconding that? Okay, well, no, it's because my point is this. In our discussion in council, we agreed to send them back to committees with the idea that it get back to council, whether you fall on one side or the other. I want to abide by that commitment, although I disagree and don't support the extension of this contract. So I'm at a bind where I can't support either one of those motions. And I'd rather us just vote it the way we feel and abide by, the reason why we're back in committee. We discussed this thoroughly in council. Let's just get back those questions, the answer to those questions, send it back to council and vote it how we would like to vote.
Which is why I didn't call it a termination. It's not an extension. And again, I want to make sure that the record reflects it's not asking for an extension, but rather a phase-out be developed.
Oh, you're asking for a phase-out?
A phase-out. It could be 4 months, could be 6. I don't know what that means.
Oh, I see.
We've got all these citations outstanding.
Outstanding.
We've got a database that the vendor holds. We've got all the equipment and the issue of pulling DOT support staff off of their ARA-funded projects that are in your districts. We've got a lot of issues out there that have to be resolved, that the contract is unclear. I think Mr. Koretz brought up some valid points that have to be addressed in the contract because we assume all of those costs. And I don't think we can do everything at all costs all the time. We've got to look at this with common sense. And so I support looking at developing and negotiating a common sense solution with a phase out. It's not an extension. It would be a phase out, which means that we'd have to figure out how to get out of this correctly.
So you're talking about no more new tickets,
without
right?
putting the burden on
Time frame.
I don't know what the time frame they've got 5 days to come back to us to council with what time frame would make sense, with what those elements would be. They've got until the contract ends to come back to us and let us know what is reasonable and rational for a phase out. What does that mean?
Just to clarify, though, you're talking about not extending the contract in terms of writing new tickets. So we'd be done. We're just extending it for the purpose of getting out of it.
Correct. And which would include support services. And as the city attorney, I think, was incredibly articulate in explaining and reading the elements of the contract and explaining to this committee that they will be providing a service that we have to pay for. There's some type of cost benefit that can be done to figure out how many people are voluntarily paying for those outstanding citations versus what we're paying the vendor to maintain the database and remove the equipment and do all of those things. There's some break-even point, and somebody can calculate what that means and what we would have to be paying where it would make sense to protect the taxpayers in the city. And I don't know what those numbers are without it coming back. Just trying to be fair.
So restate your motion?
The motion is to negotiate and work with the vendor over the next couple days and bring back to council, not continuing or terminating the contract, but working out a phase out of the contract over time to protect the city and the residents.
And just for clarity, there's only 2 more council meetings to address the issue of getting it back before the termination, and that's either Wednesday or Friday.
I think that as a last comment to that, looking at it any other way for political purposes or looking at any other arguments, whether it's the Arizona issue, now there's a lot of issues that were brought up, and we have to deal with those as well in different contexts. But in terms of this contract, I've gotten a lot of phone calls in my office already. Having been fresh off the campaign trail, I will tell you, door knocking, as you all remember that very well, and walked throughout the district and worked with a lot of neighborhood councils and stakeholders and community leaders and editorial boards, and this constantly came up. This came up at one of the debates, the candidate debates, and was a contentious issue and a divisive issue. And looking at all those and it was mostly one-sided. I mean, most folks out there, they don't like the program for the most part, as we all know. And so we've got to look at it if we plan on having one. And the issues of the program, it was fascinating to me because I would have a discussion with somebody and I just want to share this with you. I'd have a discussion with somebody and say, you don't like photo red light. What parts of it don't you like? And they started talking about the excessive fees. And I think we all agree we'd rather see a municipal fee if we can have the program. And it turned out that most of the folks that I would talk to, whether there's better elements of extending red lights and yellow lights, and we have ADSAC, and we've got a lot of systems in place already to address those issues. And if we looked at what the idea of having photo red light is, and what the idea and the principle behind it would be in the city of Los Angeles to save lives, to improve safety, where it wasn't politicized and it wasn't put in council districts evenly, but we let DOT and our experts and LAPD and the vendors decide on those intersections, where there was some teeth in the court and collection systems, where it made sense from a public safety perspective, not revenue generating. People overwhelmingly that I spoke to supported it in concept based on those principles. I don't think we've achieved that, and I don't blame the current vendor, because they bought, again, this equipment, and they bought these intersections out of bankruptcy, and they're trying to do the right thing. So I think in the interest of protecting everybody, and we have a fiduciary responsibility to protect the city of Los Angeles as well as the very people who elected us to be here, we've got to look at some kind of phase out that makes sense.
Well, if we vote down the extension, doesn't that automatically assume we're going to phase this out?
No, it kills it. We have no access to the database. We have no service at all, and we assume full responsibility of trying to collect. Somehow, if the court system, for example, next month decided that they would go after and put some teeth into this and report to DMV, we have no access to the information with the vendor. That's a problem.
So we have, no, are you going to?
No, we'll withdraw. I like his motion.
Yeah.
Sensible.
All right, so the motion is that we will move this to council, will ask for a placeholder for Wednesday, so we won't violate the Friday single-purpose meeting, and that we ask that this item 8 be phased out, that we ask the CLA-CAO to work with the vendor as to the cost and the elements of phase-out, to get a clear understanding of what those costs are over time and give us a time period. Understanding you will not have all that information by Wednesday, but clearly it's a basis to get started from. And all of the clarity as to equipment and basically eliminating the equipment and how that gets returned to the vendor. All those things get worked out in some cooperative agreement. So is that kind of?
Yes,
okay.
exactly.
Can we move that with a 5-0 vote to council, and we'll ask for a placeholder with the city clerk for Wednesday.
A special meeting would need to be,
yes,
right, from the council president.
Thank you.
41. All right. Happy birthday to Mitch Englander.
From the council president, yeah, council president.
A baby. Yeah.